Extension Legal Specialist here at the University of Maryland, College Park, and I'm a part of the Ag Law Education Initiative. You may have just gotten a consent up on your screen. We are recording this webinar and it is being live streamed on Facebook. So that's just there because we do need you to consent to the recording. For those that need nutrient management credit, you will see that you can chat with the panelists. Please put in your name and voucher number so we can get that taken care of. And with that said, I would like to thank our sponsors who have been playing along. As you saw, the PowerPoint, Maryland Farm Bureau, Marbitco, Mid-Atlantic Farm Credit, the Harry Hughes Agroecology Center, and the Maryland Nursery, Landscape, and Greenhouse Association. With that said, and I believe next I am going to play a video welcoming you from Dean Craig Beyrouty here at College Park in the College of Ag and Natural Resources.
My name is Craig Beyrouty. I'm the Dean of the College of Agriculture and Natural Resources at the University of Maryland in College Park. And on behalf of our colleagues at University of Maryland Eastern Shore and also the Carey School of Law in Baltimore, I want to welcome you all to the Agricultural Law Education 2020 conference. This is a conference that we hold every year. This year is, like many of the years, focused on many topics that we feel are important to you and the work that you do on a day-to-day basis. Topics such as risk management in dairy, which was conveyed on day one, as well as ambient air quality of poultry. In day two, we covered the Conowingo Dam settlement and also watershed-wide efforts to reach 2025 restoration goals. And today, the focus is going to be on waters of the United States and the impact that it has locally. And then also, we're going to be covering new hot topics that are developing in the agricultural sector as well. We've got outstanding speakers that will be presenting today. The Agricultural Law Education Initiative is one that we take an awful lot of pride in. Outstanding folks that are leading this overall program, helping individuals maneuver and understand the legal aspects of the kinds of things that we deal with. This program, by the way, is unlike any program that you'll find in the United States. We are one of the few, if not the only program like this, where we actually have 3 different institutions coming together, focusing on many of the legal issues that impact the industry, like succession planning, for instance, or how to maneuver through COVID-19. And as a matter of fact, the program that we actually are offering over 3 days is a result of COVID-19, so that we can do this in a very, very virtual format. But our folks are involved not only in presenting a conference like this, they're involved in obtaining research grants to do research, for instance, around solar technology and the legal aspects of solar technology, and also around hemp, for instance, which is another initiative that they're involved in. They're also involved in mentoring students, and they're involved in providing a lot of legal understanding, not so much legal advice, but legal understanding. So on behalf of our partners, I hope that, welcome you again and hope that you find this to be an outstanding and an excellent program today. Thank you.
Okay, and now we will go ahead and get started with the program. Today we have 3 speakers to help kind of go through what we need to know about the new Waters of the U.S. rule and how we got to this spot, and then what we can expect with a new administration coming in. So I'll introduce our speakers briefly, and then we can kind of get into some questions. And if you have questions you want to ask, please go to the question and answers box on Zoom and add those in, and we can get to those as we go along. But I'll start with Matt Leopold, who's a partner at Hutton, Andrews & Kurth. Don Parrish, who's the Senior Director of Regulatory Relations with American Farm Bureau Federation, and then Matt Pluta, who's with the Choptank Riverkeeper and Director of Riverkeeper Programs there. So I don't know if you guys want to start off with just a brief introduction of yourselves, and we can go in the order I introduced you if that works for you.
Sure. Thank you, Paul, and I appreciate the invitation to be here at the Speaking U today, and thanks to the university as well. As you heard, my name is Matt Leopold. I'm a partner with Hunt and Andrews Kurth in Washington, D.C. I joined this firm recently, and I came from the U.S. Environmental Protection Agency, where I served as the general counsel for almost the last 3 years. During that time, I was one of the co-authors of the Navigable Waters Protection Rule, and the primary attorney responsible for defending the rule in the courts. And so I look forward to talking to you about that today.
I'm Don Parrish. I'm Senior Director of Regulatory Relations. I've been with the Farm Bureau quite a number of years, almost 30 years, and this issue of what constitutes waters of the U.S. has been an issue that has been at the heart of a lot of Farm Bureau policy. Our members are very supportive of clean water, but they like clear rules. We all know that we have to comply with the law, and the more clarity that we have around what constitutes a definition is imported as waters of the United States, the more we're able to kind of help our farmers comply with that law. So, we're here at a point now where, from our standpoint, Matt Leopold, we're very appreciative of the clarity that you guys brought to this subject, the Navigable Waters Protection Rule. And, the proof will be in implementation, but so far we've been very pleased with what we've seen and the clarity that farmers and ranchers are, can count on.
Great. Thanks, Paul. Thanks for the introduction. And hello, everyone. My name is Matt Pluta, and I'm the Choptank Riverkeeper with Shore Rivers. We're a water quality protection group on the eastern shore of Maryland, dedicated to the protection and restoration of our waterways, using science-based advocacy, restoration, and outreach. And being a water quality group, of course, we're focused on how the new rule may and will impact water quality on the eastern shore, where we've got very valuable rivers that are already suffering from too much pollution from nutrients and sediment. And so, really thinking about how weakening any sort of restrictions or oversight might actually result in more pollution into our waterways and potential crop loss is a concern of ours.
Okay. So I guess I'll get us started with the first question. So how did we get to the current navigable water protection rule that we're looking at? What led us to this? I don't know who wants to take the first stab at that, and then we can kind of feed in with others.
You know what? I've been around this issue a long time, Paul. Let me take a stab. Going back to the year 2000, the Supreme Court ruled in a case called Solid Waste Management Agency of Northern Cook County that limited, the regulatory reach of the Clean Water Act. Statutorily, navigable waters mean waters that are kind of connected. That case was about an isolated body of water that was at the bottom of an abandoned gravel pit. The agencies moved, or at least the court moved in the Supreme Court to narrow that decision. Several years later in Rapanos, they did the same. They kind of basically said that the agencies had overreached, and there was a real opportunity to try to redo a regulation that embodied kind of where the new law stood. We didn't get that opportunity to comment on that. The Obama administration, when they came into being back a number of years ago now, they came about or put together a guidance document to try to define what waters of the U.S. was at that point in time. And they took that from a guidance document into a regulation that, from the minds of farmers and ranchers, probably more or less wrote both of those Supreme Court cases out of existence. So, that regulation technically wrote the term navigable out of the Clean Water Act. So it was something that really concerned farmers and ranchers because it brought the Clean Water Act right into the middle of where they had to farm, and probably shifted the Clean Water Act from being a statute that regulates water quality to one that regulates land use. So that's kind of where we are, or where we were, until we got the Navigable Waters Protection Rule.
Okay. And feeding off that, sort of how does this rule provide, more, if we're looking at certainty to landowners, how does it provide more certainty to landowners than the previous WOTUS rule?
I think Matt could probably talk to that, but I'll also say that I think it clarifies, really 4 categories of water. Territorial seas and navigable waters, wetlands, adjacent wetlands and tributaries, lakes, ponds, and impoundments. It puts those definitions in place in ways that we think have very commonsensical, almost, conversational definitions in ways that people can understand it. So we think that was a step in the right direction.
Yeah, I'll be happy to take that on as well. And I think Don's done a nice job of summarizing kind of where we're at today. And I'll throw another date out there. It was 1972 in the passage of the Clean Water Act where Congress really created this problem. Court after court from the Supreme Court on down have recognized that this statute is incredibly vague. And over the years, the agencies, but the EPA and the Army Corps of Engineers have tried to explain what the scope of the waters of the United States is. But through litigation over those rules, it has left really a mess in terms of a long-running court battle over that has changed over time what the definition means and expanded, contracted. But most recently, when we adopted the clean water, the navigable water protection rule at EPA with the Corps, what we were reacting to was the 2015 clean water rule that was adopted in the Obama administration. And that rule, we concluded was an overreach of even the vague authority that was provided in the Clean Water Act. And so how we attempted to provide clarity was through the 4 express categories that Don mentioned, as well as a clear exemption that if you are not included in one of the categories and they're as defined, you are excluded. That approach was very different than the prior rule, which left uncertainty depending on how close of a nexus that you potentially had with navigable water. And so we attempted to draw bright lines, and we also attempted to clarify how you measure waters. You don't measure in a period of drought. You don't measure in a period of flood, because as we all know, you might either include or exclude waters that have a normal hydro period. But we came up with a concept called a typical year. And that's very important because it was the first time EPA tried to set what constitutes a normal period of rainfall when the Corps goes out to measure what's a water and what's not. They're supposed to do so during a typical year based on a 30-year rainfall record. So you're not over-inclusive or under-inclusive of the waters that should be subject to and rightly considered connected to navigable waters. So I could go on and look forward to getting into it more, but those are a couple of ways that we tried to draw brighter lines, and so they're reliable and understandable by the public.
Matt, I would also add that you guys gave a lot of credibility to the Clean Water Act being kind of cooperative federalism, where it's not just the federal government protecting water, it is the federal government working in partnerships with states to protect water. And really that's kind of a seamless protection, and you guys did a nice job with that. Thank you.
Yeah, Paul, I'd like to weigh in on that a little bit.
Go ahead.
First, just emphasizing when we're talking about waters of the US, I believe we're talking about water quality. And I don't think that we can necessarily say that we can look at water quality and not look at the land use and the change in land use and how that land use impacts water quality. At Shore Rivers, we've got a water quality monitoring program. For over the last half a decade, we've been sampling over 200 sites on the waterways on the Eastern Shore. And year after year, we see that the pollution impacting our rivers are coming from the land that surrounds those rivers. You know, it's a tributary system that all the different classes of streams act as conduits of pollution and sediments into our waterways. And so I think we do have to look at the land piece of this. And to your specific question about, you know, any certainty or clarity that the Navigable Waters Protection Rule provides, I think it actually is the other way. I think it's creating more confusion. And just to share with you an example of a piece that I've heard from somebody who works with farmers on looking at different sort of ponds and restoration aspects related to that. So if you have it, for example, a pond on an intermittent stream, under the 2015 rule, there was no question that it had jurisdictional coverage. But under this new rule, we've got sort of a maze of a process that we have to go through. And that is, first, you have to determine if it's intermittent or ephemeral. And in order to do that, you have to know if it has surface water flowing continuously during certain times of the year and more than in direct response to precipitation. And in order to do that, you have to ask yourself, does it flow in, quote, a typical year, further defined as when precipitation and other climatic variables are within normal periodic ranges, for the geographic area for which the applicable area of the aquatic resource is based on a rolling 30-year period. So to me, that sounds like a lot of work that offers a lot of opportunity for confusion, as opposed to you know, the previous rule, which was more clear when working in certain areas. And so I do think there'll be a learning curve under this new rule in terms of exactly, you know, what falls in these categories and what doesn't. And, you know, of course, with anything, it's how we roll it out. You know, how are we training the people that are on the fields to identify this? And, you know, one thing I will recognize is that we need to upgrade our mapping systems to really find these streams in a way that could be ephemeral or could be intermittent, and really deciding between them. And I see Don shaking his head. Yes, I think we can all get behind, you know, more clear pictures of exactly how water is moving from our land into our waterway. And mapping is a great tool to help us do that.
So if it just one response to that, and I referenced the maze of litigation that has been happening over, you know, this rule, the 2015 rule, the prior rule, and that was we call the 86 regime, and the 2015 rule never really went into effect nationwide. It was almost immediately enjoined by the Sixth Circuit Court of Appeals. And so we don't really know, it was applied in a couple states for short periods of time before it was repealed by this EPA. So we don't know the extent of which, you know, application on the ground of the Obama era rule would have been simple, confusing. I would agree in one respect that it was much more expansive, and it took, if there was any question, it most likely would include the waters as jurisdictional. So in that sense, you know, if you consider that more clarity, just including everything, it had a bias towards inclusion. And, you know, but everyone recognizes drawing a legal jurisdictional line between what's in and what's out is a very hard task for any administration. And so particularly with, you know, ecological variables and hydrologic variables and state and federal jurisdiction, it's not an easy task. And so while we tried to draw bright lines, we recognize there would have to be expertise applied in the field too.
Yeah, I concur with that, Matt. It's you know, rulemaking and defining a term that does have very vague and potentially far-reaching implications. It is something that deserves a lot of thought and a lot of effort. I think that's something that you guys spend a good bit of time on, particularly as you define what categories are waters of the U.S. and then, you know, with the exclusion that goes beyond that. And to respond to Matt, you know, we all kind of recognize that, you know, where we build roads, where we build homes, schools, you know, how we live, you know, impacts water quality. But that's probably larger than the regulatory scheme that is developed within the Clean Water Act. Yes, the Clean Water Act is a comprehensive statute. It deals with some sources of pollution with permits. It deals with other sources of pollution, with incentives and grant programs to states. So again, it goes back to those partnerships. I think we've got a statute that can be protective of water quality, but we need to use the tools that Congress gave and not try to expand, kind of the legal aspect of the Clean Water Act in ways that we don't think Congress, at the Farm Bureau, that we don't think Congress did when they passed and defined those terms back in 1972.
We've gotten some questions that have come in, and I'm not sure how comfortable people are answering these, but with the first one, it kind of feeds into what we've been talking about is, could any of you go into detail and describe the scientific basis for the new rule versus the Obama era rule?
Don, unless you want to take the first crack at that, I can attempt it.
Let me try the first crack. You know what? We all learned in the 3rd grade that there's such a thing as a hydrologic cycle. And that if a drop of rain falls out of the sky and hits the surface of the earth, it could wind up in the ocean. We all know that. But we also know from the Science Advisory Board's panel on connectivity that those connections are based on a gradient. And, some of those connections are important enough, I think, for the federal government to step in and regulate. But there's also other connections that really does get into the kind of the nitty gritty of what I think both Matts and I recognize, which is you move away from a statute that regulates water into one where you're regulating land use. And I would argue that, from a statutory standpoint, Congress has never authorized any federal agency to regulate local land uses.
And so I'll just kind of summarize too, unless Matt Pluta, you want to jump in.
No, I'll let you go ahead, and then I've got
Okay.
a follow-up question for you.
Sure, I'll summarize for you what's in the preamble to the rule itself, the Navigable Waters Protection Rule, because you did hear a lot about science, and we received a lot of comments in the rulemaking process to say, oh, well, this rule doesn't recognize science. And the response, first of all, we at the EPA expressly incorporated the prior science that had been done into the rulemaking to which was known as the connectivity report. And it basically confirmed what Don just said, which is waters are connected. And that's a gross oversimplification, but that knowing that fact and knowing how that contributes to ecological, viability of certain systems, that is not enough to accomplish the task that Congress gave the agency. And the task is not simply recognizing waters are connected, but it's which waters are subject to federal permitting and which waters are left to the states to manage. And that's the task. And science can inform that question, but it cannot answer that fundamental question. That's a legal and policy call. It's one that's informed by the science, and there could be, granted different answers to the question, but science cannot tell you where a permit should be granted and where it should not. And so if you read the Navigable Waters Protection Rule preamble, it discusses that, but it does recognize the prior science and in fact incorporates and relies upon it.
Yeah, and I guess that's where I draw a little bit of confusion. So you're saying that the lawyers have taken the science and developed their own conclusions?
Not exactly, no. But what I'm saying is the way the law works is it gives the administrator of the agency, along with the Army Corps in conjunction with the Army Corps of Engineers, discretion to set policy, and policy, he has certain legal limits in which he operates. And then he has policy judgments, which can be informed on science and other factors as well. And the administrator gets to balance those factors. And he did so in ultimately coming up with the rule. So it's not lawyers substituting judgment for scientists. It's ultimately that's how policy making works.
Understood. And as a science-based organization, we tend to look at the science as sort of the path forward and how we can implement what is coming out of our science institutions and our research institutions. And we feel personally that the Trump administration's definition of WOTUS does not follow the science. And specifically when you look at the 2015 report, it reviewed 1,200 peer-reviewed articles. It took into consideration millions of comments that were talking about the connectivity of these areas, specifically ephemeral streams and wetlands, into how they impact, the physical, chemical, and biological integrity of downstream waters, which is, the real focus of the Clean Water Act. And what that report does conclude is that these ephemeral streams are very necessary for trapping nutrients and sediment. They're very, very necessary for mitigating flood impacts, especially in storm surge areas and other ways. And then they also provide habitat and tons of ecological value to hundreds of different species. And so we don't feel like the scientific evidence is there to support removing protections from ephemeral streams, just knowing how important they are to the chemical and the biological integrity of those downstream waters. And I'll just say too, ephemeral streams are important today, and they're going to be even more important tomorrow, and they're going to be even more important in the following days, because as we continue to see the impacts of climate change, these ephemeral streams are going to be more active. They're going to be filled with water more often, and they're going to be transporting more pollution. And so, really making sure that we're looking at not just the past 30 years, but let's start using our information and our modeling and our great scientific knowledge to also be looking at where we're going into the future and how important these waterways are.
So Matt, I'll respond to that, from a farmer perspective. How do you draw a distinction between what you view as an ephemeral and what farmers view as erosion features? And even more than that, water flows across our property, particularly when there are large rainfall events. And it is very difficult, to kind of parse out this whole issue of, where are you going to regulate? Where are you going to stop the regulation? Congress could have gone further, but they basically said the term navigable should have meaning. And that means more than just a connection, a mere hydrologic connection. So, you may have lofty goals. I think we all want to be protective of streams. We all want to be protective of water quality, but there is a limit, and that limit should be clear, because farmers and ranchers can take a statute that is clear, a regulation that is clear, and I think we can provide clean water.
Yeah, but specifically to that, Don, isn't it correct that under the 2015 rule, there were agricultural exemptions built into that include artificially irrigated areas, agricultural ditches, roadside ditches? So isn't your concern addressed sort of in those exemptions?
True, but the 2015 rule did define a ditch as a tributary. And, then they tried to parse out the ones that weren't. But if you start from the premise that a ditch is a tributary, all of a sudden you really cloud the issue much further than what this rule does.
Yeah, but the importance there, I think, and the emphasis there is that most of the streams and waterways on the Eastern Shore start as ditches. And so it's a hard stretch to argue that we shouldn't protect the headwaters of our streams here.
Again, I will go back to the fact that the Clean Water Act was envisioned to be a federal state partnership. And You know, I think it is probably a little over the top to be asking the federal government to regulate virtually anywhere on the landscape that water may flow, particularly if it influences land use decisions. And again, we think that, you know, if that's important, that's something that the state of Maryland has to debate. And they clearly have the opportunity to, you know, again, I've always said, you know, all water in this country is regulated. You know, some of it is regulated on one side of the line by the federal government, some of it on the other side of the line by the states. I think those are legitimate discussions and legitimate issues, but you know, I think part of the place that we have to look to is where is the appropriate level of government to deal with that.
So let me just kind of add a legal point that the most recent rule emphasizes that hadn't been emphasized previously. And, you know, Matt Pluta, you quoted Section 101A of the Clean Water Act about the goal of the statute is to address chemical, physical, and biological integrity of the nation's waters. And that certainly is true, and that was Congress's purpose. But you can't ignore what the rest of the statute says, because if you go on to read the rest of the Clean Water Act, most of it's about how Congress will allow for discharges of pollution into the nation's waters under a controlled manner. But the whole, you know, what we're talking about is pollution regulation, not pollution prohibition entirely, because Congress is trying to strike that balance between, you know, protection and use of the nation's resources. So in the Navigable Waters Protection Rule, there's another part of the purpose statute, which is Section 101B. And Section 101B talks about the fundamental right of the states to regulate their land and water resources. And so I'm basically just tying back kind of the discussion here to the statute itself, which tried to strike a balance between Section 101A and B, which is I recognize a tension between, you know, the federal goal of protection with the state's rights to regulate land use. And the courts have always said that states have the primary interest in regulating land use. And I acknowledge as well that land use certainly does have an impact on water quality. There's no question.
And I'm going to take us back to the typical year for a second. And I think there's a question in here that Joanna has asked that I guess feeds into some of what we've been discussing. But since rainfall and tidal levels and climate has changed significantly over the past 30 years, as we anticipate changes of rainfall and water to land to continue into the future, how does looking 30 years into the past appropriately determine what a typical year is? Should it be 5 or 10 years? And I didn't know if anybody wanted to tackle that as a question.
I'll give a quick answer, which is, and it partially answers Matt Pluta's question about climate as well, which the typical year concept actually builds in flexibility for climate change to the extent it's occurring. And the 30-year rainfall record, EPA didn't create that out of thin air. That's a hydrologic concept that's already in existence. And so if rainfall patterns change over time, that data is going to be incorporated into the rolling 30-year period. And therefore a typical year, 15, 20 years from now is going to look different than what it looks like today. And so that the whole point was to build in flexibility if climate or rainfall is changing.
I think I would say that the definition of a typical year under this new rule is looking backwards. It's not progressive. It doesn't look into the future in terms of what we can expect in terms of rainfall and nutrient loading going into our river. It's predicted around the Chesapeake Bay that because of the impacts of climate change, the Choptank River will experience a 22% increase in nitrogen loads from now till 2050, mainly as the result of longer growing seasons and more frequent and more intense rainfall. And so to be able to put into legislation or regulation a rule that doesn't even look into the next 5, 10, or 15 years, I think is short-sighted in terms of, you know, the intent of this, which is to protect water quality.
And I just say, does anybody have a follow-up to that? I can go to the next question if not. Okay, so looking at this, you know, we have states like Maryland, other states are going to be in this situation too, where waters may not be covered. You know, I think we've talked a little bit about what that loss in coverage potentially is, but how can states sort of pick up the ball in protecting those waters? And we have some questions that have come in too to the question and answer box that kind of feed into that as well. So I don't know if either of you, any of you want to take a first stab at that, or?
Well, my first stab, Paul, would be that you know, the Farm Bureau, you know, I work for the American Farm Bureau Federation, but we have states in every, you know, we have chapters in every state in the Union plus Puerto Rico. So, you know, how those debates take place at the local level so that, you know, as Matt pointed out in the past, so that interest gets, you know, those interests that are out there that are important, those environmental, those economic, those social issues that are clearly important, as they sort themselves out. I think, you know, the closer you get to some of these land use issues, the better off you are to try to have those discussions at the state level. And, you know, I'll be the first to say that, you know, this is not a nuclear bomb. This is something that is probably going to progress over a huge number of years. And I think, you know, we're not going to look at you know, back in 5 years and say, oh my God, we fell off a cliff. We're gonna learn, and we're gonna mold, and we're going to transition our regulations and our efforts here in ways that protect our water, and do so in ways we hope that provide the clarity that my members are going to need to continue to operate. So I think it's a combination of both. You know, I don't think the sky is falling, and I do think you know, there's going to be states that have that discussion, and they're, you know, and my counsel on those states would be to go slow. I think this rule encapsulates the protection of water that I think the public deserves. And, you know, if states choose to go beyond that, you know, that's something that they're going to debate in the State House.
Yeah, and just to weigh in on this point about the states, you know, because of this new rule, I believe that our states are going to have to really take a deep dive into, you know, their current legislation or current statutes and regulations, and, you know, identify where loopholes are now created, because we have a sort of an inconsistency here. And that begs the question, do we have the resources to do that in our government? Do we have the will to do that in our government? So there's a lot of unknowns in whether or not the states can actually pick up the slack that the federal government is letting down. And just to put Maryland on the spot a little bit in an example there, you know, we've got a number of gaps already in our budget, in our regulations, specifically our wetland mitigation fund. You know, a farmer is willing to claim hardship if they can prove that the mitigating for a wetland is too expensive for them. And here we have issues where we're then decreasing the acreage of wetlands that we have filtering our water bodies moving forward. I guess the one good thing is that the federal government did recognize that, you know, there's often an unwillingness of local governments to do this. And so that's where we have the citizen suit provision. And that's where citizens, like everybody here, can actually step up. And if your government isn't willing, or if your government doesn't have the resources, then there is that provision for citizens to step up and protect water quality.
And then, since we still have a few minutes left, looks like about 10 minutes left, I'll just ask the question, because we just had an election. What can we look to changes in the Biden administration? Are we going to stick with the current rule, or what do you guys foresee? And it's where you all get to be fortune tellers and tell us what you think is going to happen in the future. But
let me start off with that one. And you know, as the lawyer on the group here, you know, you're going to see a ping ponging of a number of regulations at the EPA, and I think this is one of them. I think so. I have no doubt in my mind that the next EPA will revisit this rule, given that there's significant opposition to it. But interestingly, there have been 13 lawsuits that have challenged it so far, and one judge has set it aside in Colorado, and that's on appeal. But another judge in the Northern District of California did not grant an injunction against the rule, which is a little different than how the Obama rule was met when it got to the courthouse. You had it set aside nationwide. 2 district courts have now said the Obama era rule was unlawful. And so what you're going to see, I think, is the next EPA has to reckon with everything that's happened, and they can't just flip the rule without explanation. That's one of the key elements of administrative law, is that you have to explain your basis for the change of policy, and policy changes are permitted, but the courts will scrutinize. And so we may unfortunately be in another period of limbo. I think chances are this rule might remain in effect for a while the next EPA, considers what it's going to do, because it takes time. It took the Obama administration, I think, 6 years to promulgate the Clean Water Rule. It took the Trump administration the better part of 3 years to repeal it and replace it. So these things happen very slowly.
I don't know if Don or Matt Pluto want to add anything in on that, or.
Paul, I would agree with Matt Leopold. It is clearly an issue that I think this administration is going to look at. I think the jury is still out from this administration as if they're going to wade in to try to change things. I think if they look at the rationale and the protections that this rule provides, I would counsel them to go slow and to, and try to figure out ways to fill the gaps, if there are any, in ways that that does not throw the baby out with the bathwater, so to speak. The prior administration, the Obama administration, could have had a much better rule if they had sat down with the ag community and worked with us, instead of trying to sell us a rule that, that regulated all water and did so in a way that impacted land use. I think this administration listened to those concerns, and I hope the next administration will listen as well.
I don't know, Matt Pluto, if you have any.
The only thing I'd like to add in is I think, there's a couple paths that could be taken. I think you could go for a regulatory fix where you almost backtrack on some of the progress that was made under the Trump administration. There's, of course, the legislative option, but I don't think anybody's willing to put the Clean Water Act up in jeopardy like that to be cut in other different ways. There are other ways. So I don't know. It'll be interesting to see. I do hope that they act fast, but they act in the basis of science. We want to make sure that science is the driving force of these decisions.
Okay. And does anybody have any concluding thoughts? And we can go in the order we started in with Matt Leopold and then work up to Don. And
sure.
Okay.
Thoughts are, we have some of the best surface water quality in the world. If you look at the World Health Organization, and we've made so much progress since 1972, when the Cuyahoga River was on fire, and the abysmal record of water protection we had in the 70s. So I think the challenge facing the U.S. going forward is, how do we allow for economic growth and development, and particularly here in the agriculture space, as we're going to need to feed more people with fewer resources and do it more productively, while also protecting our water resources. I think that's a challenge that we can rise to accommodate the interests, and letting market-based solutions lead is, in my view, one of the best ways to do that, not to potentially overreaching, command and control, federal top-down environmental regulations that and so, I think that's the challenge. I think we can do both and have economic growth and environmental protection. That's the history of the Clean Water Act and our other environmental laws.
I will agree with that. I think I'll say that we can walk and chew gum at the same time. The thing that I think farmers are going to be looking for is partners to provide incentives on the ag landscape where they're being asked to do things on their land that probably does not provide an economic return to them. They want to figure out ways to work with, larger communities as a whole, where there's development, where there is, more waste treatment. What can we do to work together instead of at odds with one another? And again, as Matt pointed out, I think there's market-based incentives, there's trading, there's probably other things. I mean, so many communities, there's an interwoven connectedness among agriculture and kind of what goes on in urbanizing areas. I think we can figure out ways to be protective of our environment, of water quality, but we've got to look beyond just the same old, same old. We have to do that in ways that provide win-win solutions, and we always talk about those. But it's more than just doing handouts. It really is about figuring out ways to kind of walk around in each other's shoes and deal with real issues. And I would whatever the Farm Bureau can do to work with municipalities and point sources and POTWs and environmental groups, so that we're addressing real problems. We want to be about that. And it's the top down, you're going to do it our way or the highway kind of approach that farmers really push back on. They're very independent. They're very motivational, and they're very, self-starters. Let's figure out as communities how to work with farmers in ways that where we can achieve the goals and objectives we want.
Great. Yeah. And just to follow up with that, Paul, I think to Matt's point, there has been some great progress made since '72 in the passing of the Clean Water Act. I wouldn't say we've got great surface waters. I'd say we have decent surface waters at most, or at best, sorry. And, I think under the current state of where things are at, we can expect more pollution loads into our already impaired waterways, given this new definition of waters of the US. And that's going to mean that we're going to have to ratchet down even more to reverse these trends. For an example, one of the rivers on the eastern shore, the Sassafras River, had a harmful algal bloom for 10.5 weeks throughout the summer that put the whole river on no contact advisory. And the more that we continue to see these negative impacts progress throughout the years, the more we're going to have to ratchet down, and the more we're going to have a clear goal on how we're going to reduce nutrients coming off of ag land, urban lands, all the land uses that we have, and making sure that we can't have clean waters into the future.
Well, with that, we have reached our time. So I'd like to thank you gentlemen for participating today. And sorry we didn't get to everyone's questions. We just ran out of time, but thank you again for tuning in today. We will be back at 3 o'clock with the next session. Oh yes, and if you can please put your nutrient management information in the chat box or email it to the email address, Marta will get you taken care of. But thank you guys again for participating.